we're going to do introductions just very quickly. I don't know if I know everyone here or not. I recognise most of your names, but there might be a few people who don't know who the hell I am and won't know who Will is either. So my name is Mike Hayden, and I've worked in the sector for 20 years or so. And I guess the key things you want to know about this stuff is that I've spent the last 12 years or so challenging councils, predominantly without solicitors kind of as backup. We'll talk about that dynamic quite soon. And on the back of that, deliver training online, which I guess is where most of you have heard of me from or encountered me before. So if you haven't, then by all means check it out. We do it every month or so. It's online, very reasonably priced, get really good feedback, and we cover the basics of homelessness law. So the 5-part test, what gatekeeping is and what homeless applications actually are, that sort of stuff. So also obviously run the YouTube channel, which is my favorite bit of all this because I think it's just a really good way to engage people and get the stuff out there. The YouTube channel, hundreds of hours literally on there now. And also run the Facebook page called Homelessness Best Practice, which is basically a place to get what if questions answered immediately, or pretty much immediately. Do some other bits and pieces as well. So I obviously do in-house training around the country as well, but these are the kind of main bits I do. And so the slides today are really things which I think I would have loved to have known 12 years ago, basically, when I started challenging Bedford Borough Council, because it turns out the law is really good. And the law is very good at getting people suitably housed if only councils would follow it. So that's what we're going to really focus on. So that's me. Will, do you want to just give a whistle-stop tour of who you are?
Yeah, hello. I'm Will. I'm a solicitor and I specialise in housing and social welfare, which is what sort of housing's morphed into over the years. So that covers a little bit of care in the community, getting people Care Act assessments and that sort of thing. But I really specialise in homelessness. And I too have a YouTube channel. I'm not as good at maintaining it as Mike is. And I've got a blog and a website, which again is quite quiet, but I try and put useful things on there. So in addition to the database of ombudsman decisions, I've recently come up with a database of case law relating to housing law. So if you do a search for William Flack blog, you should see it in there. I'm going to highlight it a bit more, but you can basically search for any case law. So the decisions that Mike refers to later on in the slides, I've checked, they're in the database. So if you want to read the full judgment, you can just go to there. I'm based in London and that's about it, I think.
Yeah, that's all good. Thanks, Will. Will's incredibly modest. I'd never actually asked him this question, but I wonder how many people he's got housed over the years. And I would not be surprised at all if it's thousands, but I won't put you on the spot right now, Will, and get you to give that. And he's also been involved in a number of high-profile cases, one of which we'll talk about today, actually, Smith v Haringey, a little bit. So, yeah, a few other bits and pieces like that. Yeah, as I say, there's a lot more to what Will does, and he doesn't get a lot of credit out there, really. So it's just really, really fortunate to have him here today. And as I say, John Allen's in the midst of us today, so John may well pipe up at various bits just to kind of add in to just to kind of maybe give some real-world experience of this stuff in his casework. In terms of the outline of the session, we're going to start with a fairly quick recap of the key concepts. As I say, I think most of you have done the introduction to homelessness law training that is online, and that kind of covers the kind of homeless applications in quite a lot of detail. So we're going to do a little bit about that. We're then going to look at a couple of just case studies, actually again taken from the training, but I've changed it slightly to make it a bit simpler for today. And then we're going to get into the common lines of resistance that you'll tend to get from councils. I think there's about 12 or 15 or so that I've kind of thought up between me and Will. So yeah, basically we'll just kind of explain what sort of resistance you'll get if you try and follow the law. And I guess some little magic bullets you can sometimes send off to a council just to remind them what the law actually is. So give you some resources, give you some citations that you can then kind of take and potentially complain with or do whatever you want to do with, really. So that's the idea. I'm going to go fairly quickly, but that does not mean to say you shouldn't ask questions, but it's fairly straightforward. So this is an old case, RGV Barnett 2003. I think it's actually a children's services case. But that doesn't matter because it's talking about what a duty actually is. And it makes the point that a local authority is obliged to comply with a statutory duty, regardless of whether it would prefer to spend its money on some other purpose. A duty must be discharged. That is the nature of a duty. That is the underlying purpose for which duties are imposed on local authorities. They leave the authority with no choice. And everything we cover today, I think, is going to be a duty. We're not, there is something called a power as well, which is kind of like councils can do it, but not every, they don't have to do it every time. But most, if not all of what we talk about today is stuff they absolutely have to do. And then that brings us to this idea of what the duty of a homeless application is. It's covered in section 184 of the Housing Act 1996, but it's a little bit kind of clunky when you try and read that out. So it's far easier to read the Homelessness Code of Guidance bit on it, which is 18.5. For those who don't know, the Homelessness Code of Guidance is freely available. PDF, if you just Google it, you'll pop straight up, basically. And although it's called guidance, it's statutory guidance, which basically means councils have to follow it unless they've got a spectacularly good reason not to. I have never seen a decision where a council didn't follow the law, didn't follow the guidance, and got away with it. That's I've never seen a good enough excuse for that. We've seen a lot of stuff in the courts in the last couple of years. There's a big case in Croydon, which basically just made the point that if a council's got a duty to do something, it can't wave its arms and say we haven't got any money. That's the council's problem. That's not the homeless person's problem. So this is our starting point. 18.5, applications can be made, and it's homeless applications obviously here, can be made to any department of the local authority and expressed in any particular form. They need not be expressed as explicitly seeking assistance under Part 7, as long as the communication seeks accommodation or assistance in obtaining accommodation and includes details that give the housing authority reason to believe they might be homeless or threatened with homelessness. This will constitute an application. There's loads of stuff this throws up. There's a really fantastic case called Edwards v Birmingham, which actually I think it'll be good for us to do a video just looking at that, because it throws up so many good answers to so many common questions. But it kind of confirms the fact that you can make a homeless application to a social service department if it's a unitary authority. There's this question of, can you make a homeless application to a librarian or a parks warden or something? And the answer is potentially. It's kind of literally that broad. And there's talk within the Edwards case as well as this being a very indulgent kind of, they use this word indulgent, this kind of very low threshold. And the point is that this is all there to ensure that people don't fall through the cracks. So yeah, that's, I guess, just that's our starting point really. In fact, the next quote is from Edwards v Birmingham, which says that there are two, and this is, I guess, kind of fundamental stuff. There are two gateway criteria for Part 7, i.e. two criteria which have to be satisfied before the provisions of Part 7 come into play. Namely, 1, a person must apply to the local housing authority for accommodation or assistance in obtaining it. And 2, the authority must have reason to believe that he may be homeless or threatened with homelessness. So there's these two criteria, that's it. There is nothing else on it. And many of the ways in which councils gatekeep is by inserting additional things to these 2 points. Like you need to provide certain information or certain documents or certain proof or whatever. That is all unlawful. And so just to pick a couple of other bits as well that just kind of again reinforce this theme. This is an older case called Tower Hamlets XP Furdus Begum. Whether he applies to the right or wrong department or authority should not matter. It should not tell that person to apply elsewhere. The game of pass the parcel has no place in this field. Again, it just emphasises that this is supposed to be a catch-all, that there should be no wrong door, that if someone is in a bit of a fix and they need some help from the local government, they shouldn't have to struggle to get it. A few other bits as well. So again, this is something I'll go into a bit more detail on the training day. The duty to refer, this is 18.7 of the Code of Guidance. The duty to refer will not in itself constitute an application. So there are certain organisations, statutory organisations like probation, prisons, hospitals, Job Centre Plus, a few other ones as well, which have a duty to refer people who may be homeless. But that only tells the council that there might be reasons to believe they might be homeless. It does not actually ask for help. Therefore, it does not actually satisfy the 2 conditions of the homeless application. Therefore, you ain't making a homeless application. So for those watching who come from one of those statutory organisations, do the duty to refer form. You have to, that's a duty. But you also essentially want to follow it up or even preempt it with the kind of email that we're going to be constructing today, because that's the bit that actually triggers the application. A lot of professionals in those kind of sectors have given up doing duty to refers because they never work. But the reason they never work is because they're not actually homeless applications, basically. So that is a very quick recap. We will now start to look at constructing this email to the council. I will talk more about why the email is the best way to do it, because we've seen you can do it any way you want. So you can walk into a council, you can ring them up, you can do it in a number of ways, but doing it via an email is by far the best, because you then have proof of what you sent and when you sent it, and that's really important. That is why I would, I would certainly not use a council's online portal or something to make a homeless application, because you don't have proof of what's been sent. You might get an automated message saying we received it, but then it's kind of lost in the ether, and you want to have that proof your end to make sure you know what's been done. So the email, as I say, we're going to play around with it and kind of construct our own little emails. By the way, if you're kind of here, then I would suggest you get a bit of a pen and paper out, something, because we will be literally kind of fleshing out how you write these emails. And obviously, because people will be coming from different remits, different sectors or whatever, it's always going to be slightly different. But you should, by the end of today, have a working template letter basically that you can then use as an email to trigger future applications. But effectively, in this initial trigger email, as a bare minimum, you first of all need to actually satisfy those 2 points of section 184, which are probably in the slides. So Joe Bloggs is homeless. He wants your help to get him housing assistance. That would be the two things. Again, we'll flesh that out as well. You then want to look at this 5-part test to kind of certainly provide as much information as you can do at that point. Obviously, you're not going to know everything at that point. It might be you've only just met the client or whatever at that point, but you want to say what you know and say why you think essentially making the application is worth their while. You also want to be very, very careful to include details about the household members' disabilities, any disability they might have. It might be as simple as saying something like, Joe Bloggs is a wheelchair user, therefore he's going to need level access accommodation, something like that. Technically speaking, I'm pretty sure it's actually the council's duty to figure that stuff out themselves. However, we're not trying to play a game here. We're trying to just make sure that the job's done properly. So by flagging this stuff up and also specifically asking for the adjustment, you're maximizing the chance of it going smoothly. It still won't work all the time. You'll still get silly things happening because housing officers won't actually read your email a lot of the time. But you just do what you can, really. And also things like care and support needs, educational needs, anything else that might kind of fit into it, potentially family support, that may be covered in local connection already in the 5-part test. But these things is what the council is going to need to know very quickly to work out, first of all, if the emergency accommodation duty section 108 is triggered, and if it is triggered, what type of accommodation is going to be needed to kind of to discharge their duty, really. So you're kind of giving them everything they should need, and then if they go and ignore it and stuff like that, then at least you've got pretty good start for a complaint down the line. Let's start with a case study. I think this is the best way to learn in my experience. So you may recognize this case from the training. I've simplified it slightly just to make it more fluid, kind of straightforward today. So it's about this lady called Rhea Smith, and Rhea was a British national. I'll read it out. Rhea was a British national in her early 60s and lived with her husband in their home in Minford, which they owned outright for 12 years. Rhea had diabetes and has sections of both feet amputated. Consequently, she has had real difficulty in standing up and walking unaided. Her husband worked in a police role, provided a lot of support to Rhea in terms of cooking, cleaning and shopping. But Rhea reported that she was subject to abuse from him and had been for many years in the form of financial, psychological and physical abuse. Rhea had been previously assessed under Section 9 of the Care Act, but she refused all the support because she did not want strangers washing her. Rhea wanted to flee, but she did not want to stay in the Minford area because she believed her husband would be able to easily find her. So that is based loosely on a real person. We've got a lot of things happening here. The care and support needs are very relevant to work out how to practically support Rhea, but actually legally, this is a pretty straightforward case. There is really no doubt that should she remain in her home, that the abuse will likely continue, or the risk of abuse will certainly probably continue. Therefore, she's going to, pretty easily meet the Section 177 definition of homeless because of domestic abuse. The key thing being, it's not about the severity of the abuse, it's about whether the abuse is likely to continue. So that means she's homeless. And because she's homeless because of domestic abuse, that is also going to mean she's going to be in priority need. So that, again, legally, it's very straightforward. Practically, it's more difficult. And the fact she's a British national who's lived, as far as we can tell, in the UK for many years at least, she's also going to be eligible. And these are important because these are the three things that come into it with Section 108. So this is our presenting situation. Once imagine you've met with Rhea, you've sat down, you've done an assessment, you've gleaned all this information from her. Maybe you've got additional information as well from other services. I think in this service particularly there was IDVA involvement, that sort of thing. So you're going to have potentially other sources of information already. But clearly this emergency here, this is someone who needs to get safe as soon as possible. And so in terms of constructing the email, there are two cases we're going to do this for, by the way. So this is the first one. This is the kind of wording I'd use. And again, we're going to send these slides out, or we're going to get these slides to you. And again, I'm going to come to the resistance afterwards. So this is the email that you would write, but I can guarantee that this won't work on its own. You're going to have to follow it up with some other bits and pieces. So the first section of this, dear ex-counsel, so whichever counsel she wants to go to. Obviously, there's more to say about that as well. I'm currently supporting Miss Rhea Smith to obtain safe housing. Miss Smith has given me her consent to make an application on her behalf to ex-counsel. I have pasted in a copy of the consent at the end of this letter. Now, this is important because to make an application on someone else's behalf, you need their consent to do so. But if you have their consent, as we'll see later on, that means that you can do it. That's kind of enough to make the application. And I guess you could argue that, I mean, obviously people are welcome to do it themselves, but obviously, as we're seeing already, there's quite a lot to this homeless application business. So I don't think it's unreasonable or disempowering to basically do this bit on someone else's behalf. It's likely they're in a bit of a real fix at the moment anyway. So I think that's generally speaking, that's good practice. I'm sure there will be people who are capable and want to do it themselves, but I think I'd say in most cases, they're probably going to be quite happy with someone else who knows what they're doing to actually do it on their behalf. But that anticipates one or two of the problems that we're going to encounter down the line. Then goes on to say, and effectively what we're doing here is we are hitting the first of the 5-part test. So we're showing that Rhea is likely to be homeless. We don't need to prove it yet, but we just need to give the council reasons to believe that she might be. So it says that Miss Smith lives at X address, which she jointly owns with her husband. Miss Smith is currently being supported by the IDVA service as she's reported long-standing domestic abuse dating back years, and she wishes to access assistance from your council to obtain safe housing. I have attached a copy of her most recent DASH assessment form and a recent letter from her IDVA about the ongoing risk of domestic abuse that she's at. So again, just a bit of jargon there. So the DASH form is the form that anyone can fill in order to access domestic abuse support. It's kind of a scoring system, and it's, one sense it's helpful for a number of reasons, but it's likely that in that DASH assessment there'll be plenty of evidence to say that the abuse is ongoing. And also the IDVA, hopefully you've got a helpful IDVA here. My experiences of IDVAs are generally very good, so they are probably also going to be in a position to give their professional opinion about whether the risk of abuse is likely to continue. There's a precedent from Kelly v Westminster, which again I cover on the training day actually, but basically that case involved professional expertise being basically been ignored by a council, and that was found to be unlawful. So where you have a professional, doesn't have to be an IDVA, could be social worker, could be medical, whatever, when they give an opinion about the relevant information about the risk of domestic abuse or the risk of kind of medical issues or whatever, then their opinion holds a huge amount of water. It's very difficult for a council to legitimately ignore that. So it's likely that, again, we've probably already done far more than we actually need to here to trigger the application, but we're not trying to make it difficult. We're trying to make it as smooth as possible. Therefore, we're providing this information because we have access to it. There will be cases where you don't have that available, but so you have to trigger the application without it. As we've already said we haven't actually said it in these words yet, the trigger, the threshold for making an application, the threshold for councils acting on Section 184 is a low threshold, and it's meant to be it's designed to be like that. It's meant to be low to ensure that, as I say, people don't fall through the cracks. So yeah, we're in a good position here actually to have that level of information, but you don't need it. But certainly whether or not you have it right now, you should be seeking it as soon as possible. It may just be that you can't wait until you get it back before you actually trigger the application, because there will often be some urgency here. So that's our first, but that's done two things. These two paragraphs have done two things. One is it shows you've got consent to make the application. The secondly, it's basically given the council reason to believe that she might be homeless. So Section 184 is now satisfied as soon as the council receive the email, basically. What we then want to do is we want to show that there is also likely going to be a duty to provide emergency accommodation, interim accommodation. So that is all around Section 108 of the Housing Act. Incidentally, those two sections, Section 184 and Section 108, are probably the only two you actually need to know. There's lots of other sections, obviously, but these two are going to be the two key ones. And because we've already established that Rhea might be homeless, we're then going on to tackle eligibility and priority needs. So, first paragraph here, Miss Smith is a British national who's lived in the UK her whole life. Until now, she's been financially supported by her husband, and we're exploring making the UC claim as soon as possible, as well as a claim for PIP. Now, the reason I put that in there, one is the council probably need to know that anyway, because it's part and parcel of the support that needs to be provided to Ray in terms of getting financially independent. But a lot of councils will basically judge eligibility based on whether someone's in receipt of UC. And so by just making the point, she's not in receipt of UC right now, but seems like she's eligible, she just hasn't claimed it before, that is going to be enough to probably kind of cross that threshold basically. So just question come in on the chat. Is there a difference between the duty to refer and a homes application? As a caseworker, we always complete a duty to refer on the online Jigsaw website. Okay, so there's two there's a really good question. There's two issues I would take with any council that do that. So first thing to say is that although the duty to refer only applies to statutory professionals of certain organisations, as we've seen, so if actually I go back to 18.7 or whatever is the code of guidance. So this is our kind of our reference here. As I say, only certain professionals have a duty to refer. Some councils will insist that everyone uses the duty to refer form. That's basically that's naughty. Basically, that's frustrating the purpose of the law, because as a voluntary sector worker, if you just do the duty to refer form, it might even say it in the small print. Often it actually says in the small print at the bottom of the letter, this doesn't trigger a homeless application. And so that's the first thing you're going to have to battle with the council, because they'll get very annoyed that you're not going to use their online form, which has been designed specifically to frustrate the point of the law, by the way. It's none of it's accidental. They have made it that way to make it more difficult to make applications. So that's the first thing you have to worry about. And the second thing is they're going to have a problem with the fact that you're not using the online Jigsaw or online portal or whatever it's called. Councils use different systems, but obviously Jigsaw is quite a widespread one. But yeah, so if all you do is the duty to refer, if you don't do this email, then you're not actually triggering an application. And the difference is that when you trigger a homeless application, the homeless application can't be closed until at the very least there's been no contact for 56 days. That's what the guidance says. Whereas if you just do a duty to refer, what happens is the duty to refer comes in, the officer tries to ring them up once, one bellum, okay, no answer, put the phone down, and that's the end of it. There's no real kind of further duty or further work done in there, which is why it's so important to dodge the duty to refer. As I say, some professionals have to do it, but as well as doing it, you want to be putting an email together like we're covering at the moment, because that is going to be the thing which cements your kind of your stake or your client's stake in that process. It then becomes very difficult to shrug it off. That's the purpose of doing it this way. But yeah, so in fact, that's not something I anticipate. So I'll come back to that. It's a good question, because when we come back to the resistance you're likely to encounter later, that literal annoyance you're going to get from senior housing officers or whatever, managers or whatever, because you're refusing to use the Jigsaw system or whatever, that's something you'd have to navigate. And probably my advice to you on that would be, say, yeah, do it via email. You'll then get a manager or someone ring you back saying you need to use a Jigsaw form. You say, okay, great, I'll do the Jigsaw form, but you need to acknowledge that a homeless application has been made and that they're actually taking the email. And as I say, you might then kind of cite 18.5 of the code guidance as one way of showing that. But that's important. As I say, something I haven't said yet is that if you're not willing to stand your ground, I'm not quite sure what you can get out of this for your clients. There will inevitably be a crunch point when someone gets their back up because you're basically daring to use the legal system as it's specifically been designed to use. Now, if you're not in a position to challenge councils because it might be your funding or whatever comes from them, this would be when you would consider getting a solicitor involved. Because in one sense, if you trigger the application and the council saying, no, you need to use this form over here, that is already unlawful. And so, Will, in that, I would have thought Will can obviously answer this question probably better than I can, but I would have thought that even just getting a solicitor involved and just kind of, flashing your teeth at them, that would probably be enough to get them to rethink that. But I don't know how, Will, do you have judicial review processes on this kind of thing just because a council's refusing to take an application via an email? Do they ever actually stand their ground on that?
Yeah, definitely. I've got standard letters that I send out to councils, either because they've simply ignored a homeless application like this, or because they've come up with some reason that they say entitles them not to do it. So it literally, I just fill in the blanks and send it off. And that usually gets them to process it because they know they haven't really got a leg to stand on. But yeah, I mean, I've got a little library of pre-action letters that get used regularly. But the failure to process a homelessness application is probably number one in the list.
Yeah, yeah. I mean, something I also want to say is that Will predominantly works in London, whereas me and John have almost always worked outside of London. Outside of London, you've got a much better chance of getting your council to follow the law than you would if you were in London. So in London, I'd say you need to know the law because you need to know when to invoke a solicitor. But outside of London, I think there's a lot of grounds for getting good outcomes without even needing to even kind of threaten solicitor action or whatever. So we're basically just working our way through the 5-part test, but we're focusing on the first 3 because those are the 3 that matter at this point. Whether someone's homeless, eligible, in priority need, or if there's reasonably they might be, is going to define whether there's going to be an offer of emergency accommodation immediately, basically. So this paragraph here is dealing with eligibility. It's basically saying she's eligible. Certainly there's reason to believe she might be. And this second paragraph here is basically coming back and just reinforcing the fact that she is homeless because of domestic abuse, therefore she's in priority need because of it automatically. So it says, as you can see from the IDVA's letter, the IDVA is of the opinion that should Ms. Smith continue to live at the property, that is probable that the risk of domestic abuse will continue. I believe further information can be obtained by Minford, which is the fictional place's Marrick. Again, sorry if I'm using jargon. And the Marrick is it's the multi-agency risk assessment conference. It's basically a multi-agency meeting that focuses on domestic abuse, and it will be chaired by a council. But there'll be police and other probation stuff involved as well. So that should be enough to show the council that there is a duty to provide emergency accommodation immediately. Again, that does not mean to say that councils will follow the law, but again, it's about doing what you can do, because if you've sent this information through and the council then ignore it, you are immediately in the kind of world of compensation claims, because basically if a council was to receive this information and didn't make interim accommodation available immediately, there's going to be a sum of money that they will need to pay should that person or you on their behalf complain through to the local government social care ombudsman. So yeah, this and that would be kind of classic gatekeeping stuff, basically. So next bit here, as I say, we've done enough to trigger section 108. We're now basically just giving information that the council is going to need to actually discharge their duty, because there's lots of other things they need to be thinking about, one of which is going to be suitability of accommodation, because any accommodation that the council provides has to be suitable. And we have a wheelchair user here, or someone who, if they're not using a wheelchair all the time, they're probably dependent on some kind of aids and adaptations. So it goes on to say Ms. Smith suffers from significant medical conditions that both affect her current mobility and are also likely to deteriorate if not properly treated. It seems that these conditions would certainly qualify as a disability, and it seems clear that she will need level access accommodation as well as other aids and adaptations. It therefore seems to me that she would benefit from a fresh Section 9 assessment under the Care Act 2014 to ensure that she's able to carry out day-to-day living activities and any accommodation that she's offered. Because bearing in mind, for Rhea, up until now, her husband has been providing significant care and support, but he's just also been abusing her. If you are going to basically house her, you need to, or the council need to figure out how are they going to ensure that her care and support needs are taken care of. And so, yeah, I mean, it's going to be a different area most likely. So a fresh Section 9 assessment will be needed anyway. But that's going to be something which is really important to do, because effectively housing are going to need to work hand in glove with social services to ensure that Rhea's experience of the process actually is kind of, is possible to follow. There's no point sticking her in a concrete shell of a flat and giving her no support, because that's likely to fail very quickly. And there's also this additional bit of information here. Due to the alleged perpetrator working for the police, it is imperative that you liaise with the Minford Marrick chair before undergoing any other inquiries about the domestic abuse to ensure her safety. So again, there will often be specific things you need to tell the council. This is just one example of many, but the council need to know this so they don't kind of wade in and start making inquiries that actually then identify, if they rang up the police and said, Rhea Smith's getting abused, what can you tell us? You never know who in the police is receiving that call. So you just need to make sure that the council's given enough information to actually be able to ensure the safety and well-being of people who are applying to them. As I say, that's just one example of 100 that you potentially could have. It just depends on the circumstances. And then finally, and this bit is probably a bit weaker because they're probably going to ignore this, but it's worth trying. So Miss Smith has asked that you copy me into further correspondence and inform me of any planned assessment meetings. In reality, most councils will just flatly ignore to do that. And I'm not quite sure if they legally have to. I mean, it's good practice to, obviously. And if the particularly if the individual's got care and support needs, then that should basically be, other professionals, other supporting professionals should definitely be copied in. But as I say, in reality, I'm not quite sure how often that actually happens. Please let us know what support you will offer her and what she needs to do to obtain it. So that's kind of a way of saying when you're going to house her and how you're going to do all this, basically. And then finally, I've attached a copy of Miss Smith's birth certificates and utility bills in case you need them. Please let me know what other documents you require so I can support Miss Smith to obtain them for you. So that's not necessary. Just to make the point here that you don't have to do this. But again, we're not trying to be difficult. We're trying to make it as smooth as possible. So if you have these kinds of documents, then basically attach them, do what you need to do to get them to the council, because this is going to help the council follow the law. As I say, you're not trying to catch them out. You're just trying to make it as easy as possible for them to discharge their duties legally. And that's it for the time being. Yours faithfully, whatever, Mike Hayden, off they go. I am a real stickler for data protection stuff, so I would have basically included all this information in a password protected letter document, a Word document, and attached it to the email and basically ensured the password is getting to the right person. I appreciate lots of people probably aren't as such sticklers for data protection as I am, but that's how I would do it. So it'd be a self-contained letter with a password that goes with it that kind of follows the email or whatever. That is then sent off, and then you kind of pray that the council's decent enough to pick up the email. They have a duty to, so they should do, and also take necessary action immediately to try and ensure that Raya is basically dealt with, kind of lawfully, and is given the support she needs to keep her safe. In reality, I mean, even a council that's good at this sort of stuff, because it's such a complicated case, because of this care and support needs and so on, it's going to be quite difficult. I mean, I'm not going to go into what actually happened in this case, but one of the things that happened to the real person this is involved was that the council's initial response was, yeah, we accept we have a duty, but we don't have any wheelchair accessible temporary accommodation. And so they took them like 10 days or something to actually find wheelchair accessible accommodation for her. That's obviously not lawful. That's going to be part of your complaint down the line, but that's just the reality of kind of working with what you've got, I guess. But yeah, that's Raya. Any other questions about Raya? We're going to do another case study next, and then we'll start looking at these kind of common resistance kind of bits you get into. So doesn't look like we've got any questions. So let's go to James. Again, this is simplified it again slightly from the online training, but it's the same sort of thing really. So James was on Universal Credit and PIP. He'd been homeless since childhood off and on, and spent several periods in prison. He'd lived in Mitchborough for nearly 10 years, mostly sofa surfing in the night shelter in prison. He had lost most of his most recent hostel place when he went to prison. Now, when I say hostel there, I mean supported accommodation. I should probably change that actually, because a lot of places that means to be temporary accommodation. But no, it means like supported accommodation, like a YMCA or something. He was diagnosed with PTSD and borderline personality disorder, for which he was treated with antipsychotic medication by his GP and CMHT, but he'd often disengaged with his support. He was temporarily accommodated by Mitchborough and accepted as vulnerable, but found intentionally homeless, so he was evicted 28 days later. He did not challenge the decision within 21 days. A few months later, while subsequently rough sleeping, he was attacked and had all his belongings stolen, including his ID and medication. So again, I'm not going to sort of labour the point here. Your email is going to cover the same things that Reyes did in the same sequence. So, he's homeless. That's going to be a very short paragraph because he's obviously homeless. He's rough sleeping. There's not much more to say about that, really. And it's pretty obvious he's also eligible because he's UC. He's lived in the area for many years. But the difference here between Raya and James is that whereas Raya, it's actually quite straightforward to show priority need, or certainly reasons believe that she might be in priority need, there's a bit more to it with James when it comes to showing that he is going to be in priority need, because you're going to be relying on his vulnerabilities. And as you can probably see here, there's multiple sources of vulnerability here, so it's not like it's going to be difficult. But that does not mean to say that, just because it should be obvious doesn't mean the council's actually going to do the right thing. There are two, I call them tests. They're not, I don't think, they're not, that's not a widespread term. There's basically two cases which are very good, are the best sources for understanding what the definition of vulnerability is. The best one is Thomas v. Lambeth. The downside of this case is that it was only a county court judgment, so it doesn't hold the same legal weight as the other one, which is technically called Paniotu v Waltham Forest, but it involved the Smith v Haringey kind of element of it. Long story short, basically, and that was a court of appeal case, so that has a lot more weight legally, but it's also far more kind of convoluted as to how they kind of came up with the definition. So, for the purposes of today, I'm just going to use the Thomas test for James. This is the actual test itself. This kind of comes out of that case. So firstly, does James have an identified existing issue that the ordinary person will not have? And again, this word ordinary just ties in with the case law. It's not, it's obviously quite clumsy language, but that's what we've got with. So for James, he's got a multitude of things which the ordinary person would not have. The fact he's on PIP, the fact he's been homeless multiple times, the fact he was homeless since childhood, the fact he's been in and out of prison, the fact that he's not managed his own tenancy, the fact he's got PTSD and borderline personality disorder diagnoses, the fact he's on antipsychotics, which have now been stolen, and the fact he doesn't engage with the support, the fact he's already been assessed as being vulnerable by Mitchborough, the fact he didn't challenge his decision, and the fact he's now been attacked and had his other stuff nicked as well. These are all things which the ordinary person does not have to deal with in their life. So we are comparing James with that ordinary, healthy and robust person without any of these issues. So that would be the answer to the first one. Just list the issues, really. And then we apply the second part, which is, would the consequence of the issue be significantly exacerbated by being homeless? Now, again, there's almost, it's almost a case that you can't see the wood for the trees here. Actually, it's very straightforward. The easiest way to show this is just using the diagnosis of PTSD, because PTSD is firstly a condition which housing officers, they kind of respect as being a real issue. I say that because lots of professionals don't really regard personality disorders as being a real thing. So PTSD is probably the easiest one to go with. And also most people probably understand the general kind of traits of PTSD, so high levels of anxiety, insomnia, flashbacks, paranoia, that sort of thing. Now, obviously, for somebody who's been beaten up whilst they were rough sleeping, all of those things are likely to get worse. You shouldn't really need a doctor to say that, but I guess you may well do sometimes. So that would be the answer to the second part. And the third part of the test: could those consequences, as in things being exacerbated, include increased risk of harmful effects? Yeah, well, I mean, they're harmful effects in and of themselves. You don't have to really go much further than that. If you've got someone with PTSD who's just been beaten up while rough sleeping and their symptoms are getting considerably worse, that's a harmful effect in itself. That's technically all you would need to make the argument. And again, you don't have to be kind of fleshing out the full argument when you're triggering the application. You're just giving the council reasonably that you might be in priority need. Any council officer who does not see that this person might be in priority need is just an absolute dog, basically. But there are, as happened in this case, you have got those housing officers out there who just basically don't care. They just don't care. In fact, they're quite vindictive a lot of the time. So just because it's obvious, just because it's blindingly obvious that low threshold is met, does not mean to say you're not going to have to make the argument and dig your heels and down the line. So that would be, as I say, I'm not going to kind of give you the wording for the whole email because it's basically the same as Raya in most cases. But when it comes to vulnerability for James, you wouldn't go down you have to show why he's vulnerable, because he doesn't have any automatic characteristics. So that brings us to the end of the second kind of section in terms of kind of giving us these templates. We're now going to get onto the third section, which is the kind of resistance you're likely to get, which is probably the most fun, or not fun, most interesting. So yeah, there's lots of different things to say about this. One is that the staff member you deal with probably started doing their job because they wanted to help homeless people, but they've probably been trained specifically to frustrate the law. Their policies, their procedures are probably all designed specifically to frustrate the law. And they're also in a very bureaucratic kind of state. So you can't win an argument just verbally. If you're right, you're still not going to win the argument. You can quote the code of guidance at them, you won't win it. They'll just dig their heels in basically and have that computer says no mentality. So therefore you're going to have to dig your heels in back, basically. There's no way. I've never seen a council do the right thing without having some kind of threat of complaint or threat of something kind of hanging over them. So whether it be judicial review or whatever. And this is just a quote from a fairly recent Southwark LGSO decision. And it just kind of makes the point that councils will be perverse quite way into the complaints process. So basically, this person, Miss X, made a homeless application. and the council said you need to bring some proof of this stuff, and basically she somehow got through that stage somehow. And then when she made a complaint about it, or an advocate made a complaint about it, the first stage complaint from the council basically just upheld their own decision, which was that they didn't do anything wrong. They basically said in their first stage response, it's the burden of proof is on the applicant. Now that's definitely not right, as the LGO says here, that this is in stark contrast to what is described in the Homelessness Code of Guidance. So what I'm saying here is that senior managers, because a senior manager would have written that first stage complaint response, they will knowingly. There's no way that I can't imagine that complaint that manager would not have known what the law was. And if they didn't know, then they should have checked. It's not difficult. It's pretty obvious in the guidance. So what that means is you're up against this kind of machine of just people who just don't seem to mind twisting the law, kind of misusing the law. And as I say, therefore, if you're gonna get your client the assistance they're owed, you're going to have to break through that resistance. So, as I said already, it may be that you're just not really able to complain. Now, when I went to the drug and alcohol service in Bedford, I've told this story to some of you. So, I started doing this stuff. Basically, started making complaints, and my boss got a call from one of the senior managers, basically trying to get me sacked for it. And fortunately, my manager was really cool, so it was fine. But what I did start doing instead was, rather than writing it on their behalf, the complaint, I would basically write the complaint, draft it up, give it to them, and they can send it off for themselves. And that was a way of getting around it. But yeah, if you think you're going to get people housed without fighting for them, unless you're very lucky with a decent council, which there aren't many left of them, you're going to have to stick your head above the parapet at some point. So, having made those points, the kinds of common things you're going to have to deal with are as follows. And as I say, there's a list of maybe 12 or 15. I might just, that first question we had that came in about Jigsaw, I might add that to this list now, actually. But the first one, arguably the most common one, is that you get no response at all. So you make an application, you write the right email, you write all the right stuff. There's an urgent need to house someone, and there is nothing. You try and ring them up, you can't get through to anyone. That person then is homeless. You're panicking because you care about the fact they're homeless, and you have to kind of figure it all out. In my experience, there is no way to get around that. You either need to make a formal complaint to the chief exec that the next day, as soon as you know something's gone wrong, or you need to get someone like Will involved, who will then basically write some angry letters to the council, which basically show why they've broken the law. I don't know, John, if you're listening, if you want to say anything about this, John is very, very good at having no patience with councils. So my time working with John, basically, as soon as the council wasn't doing something right, John would be on their case and we'd be escalating. It'd be, kind of copying in line managers, copying in politicians. And that was an effective way of working. Unless you're willing to do that, I don't know what chance there is you're actually going to get things to work. So yeah, that's the first kind of common thing that happens, just literally nothing at all. And I had this recently with someone. So I made an application, they said all the right stuff, someone who's automatically in priority needs, and the council didn't respond at all. So sent a complaint into the chief exec, copied in the relevant councillors. That was the thing which then got things moving. Although even then, there was a couple of days before they actually did the right thing. So that's just the reality of doing this stuff. In terms of finding a John, so John, John, if you're there, feel free to speak for yourself. But John just covers Bedford Borough. The thing is, everyone's got to be a John, basically. John was working in the sector. Me and John were both working in the sector, and it was kind of taking this approach. That's what got Bedford Borough Council to follow the law much more than they used to. They're still not perfect, but yeah, that's the thing. There probably is no local John for you. Basically, that's the reality. There are very few advocacy services who know homelessness law very well. There are solicitors firms like Vogo's that Will works for, but again, they're always at capacity pretty much. So unless you're willing, the reality is that you're probably that client's best hope of getting justice. You are, even if you've never done this before, even if you don't quite know what the law is, all that sort of stuff, you're probably their best hope to actually get a good outcome for them. So that's the first one, you silence. Second one, you need to attend in person. I've had this before. We've kind of referred to Edwards v Birmingham already. That was a really key case around homeless applications and what actually triggers it. Arguably, a more straightforward case to quote or source to quote here would be Chiltern DCXP Roberts. It was basically involved some travelling showmen. Chiltern DC, I think, is in Buckinghamshire now. This was back in the 80s, I think. And the travelling showman, the Roberts family, basically instructed a solicitor to make an application on their behalf. Doesn't have to be a solicitor, by the way, just to say that any third party can do it if they've got someone else's consent. But that was basically found to be an application, and they never attended the council's offices in person, as far as I know, because they were traveling showmen. They were somewhere else when this was all happening. So the solicitor's letter actually triggered the application. That made the point. So whenever I'm kind of making a complaint that the council has told me that the person needs to come in or something, I will be quoting that case. One of the first cases I worked on in Bedford was a guy who's returning back from a fairly short prison sentence, and he was on his way back to Bedford, and I didn't want to wait for him to get there because I didn't know how long it's going to take him. So I triggered the application. I had his consent. I triggered the application in the morning, and the council manager came back and said he has to be here in person, otherwise we won't take it. And I complained, and that was in 2015. And as far as I know, they've never made the same mistake again, so to speak. They've never tried to say that again. They've always acknowledged that a person can make an application on someone else's behalf, and you don't need to attend in person. So that would be your one paragraph complaint. I triggered an application for Joe Bloggs. The council said that he had to attend in person. That's not lawful according to Chiltern DCXB Roberts. I'm therefore making a complaint. That's really all you need to do. And the first stage complaint might be upheld because they'll say, oh, they definitely do need to attend. But when you start getting to the last stage or to the LGSCO, that's when the truth starts coming out. And you only have to have kind of these arguments once, in my experience. If you've shown that you're willing to, if you've shown that you know the law and you're willing to take it all the way, then the next time you come with someone, the next person down the line, they will get taken seriously on this point every time, because the council knows that if they don't follow the law, that you're going to take it further. That's that one there. Again, feel free to ask questions. Thirdly, you need to do a homelessness interview before we'll accept the application. I should have probably grouped this together with other things, like you need to provide certain documents, you need to provide ID, you need to provide bank statements before we accept the application. That is all nonsense. It comes up with the LGSCO regularly. The Brentwood Council report that was published early this year, which basically showed that they'd been gatekeeping 90% of their clients, made the point that whilst it is appropriate for the council to expect applicants to provide information as part of inquiries, the duty to make those inquiries is on the council. The duty arises when it has reason to believe an applicant might be homeless or threatened with homelessness, not when it decides the applicant has jumped through all the right hoops. So that whole Brentwood case was basically where they were putting all these additional hurdles in the way of making an application, and that was shown to be unlawful. Yeah, again, it's about kind of bringing this challenge. There's other cases that you'll find in the database where you can find out more kind of examples of this happening. But yeah, very typical thing. And I would say it is worth, it might be that in some cases you have all the right documents to hand, submit them, but still make the complaint, because effectively you're not just trying to get the person in front of you housed, you're trying to get the system changed. If you just get the person in front of you housed and nothing changes, then someone else that you never meet won't get housed. That's how it will work. You have to push for systemic change if you're going to kind of see these kind of improvements. Classic one. You need to wait until the bailiff evicts you before we can help. I've done a lot of videos here. So again, when you get the slides, this video here explains what the law is. I've done 2 more actually recently about how you get compensation if that's what you've been told. But crucially, these links here are all LGSCO decisions. They're just examples of where a council's told people to wait until the bailiff and have had to pay compensation as a result of that. So again, you can just quote from those when you're making that complaint. So if you have a client who's basically been given a Section 21 and has been told to wait until the bailiff comes, start the complaint early. Otherwise, they're just going to be probably there until the last day, and it's going to cause a lot of stress. That's not necessary. We need to make some inquiries before we accept the application. This is another classic. Give you an example of this in Bedford. Worked with a lady who was about as vulnerable as they come, actually. And basically the council's position was, she's not vulnerable. And what they eventually said was, when they finally accepted the application, was, we'll have to speak to the GP before we accept the application. And I was like, that's the wrong way around. You accept the application first, then you make your inquiries. And so in this case, which is quoted in Edwards again, actually, which is where I got it from. So Lord Justice, I think that means Neuberger, referred to the manifest disapproval in Fahia, which is another case of non-statutory inquiries. Once the authority has reason to believe that the applicant is or may be homeless or threatened with homelessness, a duty to make the statutory inquiries by Section 184 immediately arises, and it cannot engage in non-statutory inquiries designed to, or in which in fact emasculate, dilute, or shortcut the statutory requirements. So if they're making any inquiries at all, that shows that they have reason to believe that that person might be homeless. So if they're making inquiries to the GP, that is giving you reason to believe that they might be in priority needs, and they should be housed until the counsellor knows that they're not. Another thing I see a lot with counsellors is they'll say, "Oh, we're going to write to Now Medical for a second opinion." I'm like, "Well, okay, that's fine, but whilst you're waiting for that response, there is reason to believe that they might be in priority needs, so you need to be housing them." Assuming that the kind of criteria of Section 108 apply. 6, you can't
Mike,
trigger. Oh yeah, go for it. Yeah, go on, John.
can I just reinforce number 5
Yeah. Let me go up. Hold on. Yeah, go for
about
it.
making inquiries yet not accepting an application? We had a lady and her young daughter living in the HMO, and it was unreasonable for them to continue to occupy the place for various reasons, which I won't go into. So we had given them enough reason to believe that she was homeless. They disputed that. They said, "You haven't given us reason to believe, so we are not accepting the application. However, we're going to send environmental health around to ascertain, what you have said is true." Well, I basically said to them, so you're making inquiries, therefore you must have reason to believe she is homeless. They still never accepted it. So we had to go through the complaints process to get them to accept that inquiries had been made. And so there was reason to believe. We got it upheld, but that's, it's a long way of going around to get them to recognise him. And it's this no reason to believe, whether it's homeless, eligible, or priority need, that the council use mainly to offer resistance. You can give them all the information under the sun, and they can still turn around, knowing that in most cases you have to go judicial review, and they'll say no. You still haven't given us reason to believe. And of course, if people don't know how to go judicial review, or they haven't got the resources to do so, there's not a lot they can do about that. Yeah. So, we use the complaints process. We do use solicitors when totally necessary, but nevertheless, it's that reason to believe threshold, and they understand it's a low threshold, but they use it against you just to deny you the duty.
Yeah, and as you say, like sense. Yeah, and as you say, like there's no kind of like review rights. The only way to challenge it is with a solicitor or a complaint. Now, the downside of a complaint is it can often take time to get it sorted out. But that's the reality. That's the best you can do often. So you'll often see that kind of that, because there's this relationship, and particularly in cases where the person's homeless, not because they don't have a roof, but because they have a roof, but it's not reasonable to continue to occupy because of disrepair or whatever. Actually, there can be some quite involved inquiries that need to take place, but the threshold is clearly low, and low by design, that whilst those inquiries, whilst there's a question to be answered, that threshold is going to be met, and it's not until the council's satisfied that it's not in the positive, that's when the interim accommodation duty would end. I think unusually for that one, John, you actually got an upheld complaint at stage 1, which, as I say, is generally you have to get to stage 2 or kind of start rattling kind of MP's cages before you start getting that. But is that right? Did that get upheld straight away?
Yeah, it did. But you are right. That's after being doing this job for 10 years. If it was 10 years ago, we'd probably had to go to stage 2 and then the local government ombudsman in order to get that overturned.
Yeah.
It's only because of who we are, and them knowing us, that we were able to get it resolved at stage 1. But anyone that's doing it for the first time, like you say, it's a long process to then get this decision overturned, and all this time the person's being harmed.
Yeah, and I think that probably kind of makes the point that it's usually the first one or the first couple of complaints or the first cases that you have that are the hardest. Once you've shown that you're able, capable and willing to take a complaint to the LGS, you'll start finding that your involvement in the case can actually be enough to get a good outcome, just because the council realise that they know what's going to happen if they don't actually follow the law. So they'll do whatever they can get away with in a lot of cases, unless they have a reason to think they won't get away with it, if that makes sense. So 6, can't trigger homes application for someone else. Again, the same case, Chiltern DCXB Roberts makes this case that solicitors did it. And you've also got, I mean, I actually don't think this is very helpful, but from the Code of Guidance, you've got 21.28, which is the chapter about domestic abuse, where it says, where appropriate, housing authority should accept referrals from concerned parties by allowing someone else to make the initial approach to the housing authority on behalf of the victim, provided the individual has the victim's consent. Now, that's true, but it kind of, if you just read that, you'd infer that this only applies to domestic abuse cases, but that's not the case. It applies to any case. If you have informed consent of the applicant, you can do it on their behalf. That's what the Chiltern XP Roberts case shows. And if you just Google that term, by the way, you'll get a little kind of, you'll get plenty of, like, in fact, you'll get it on Will's blog as well, kind of little summaries of what that case involved. The primary thing that case involved was that actually that the Roberts family weren't in fact homeless when the inquiries were finished, because although they were, kind of traveling showmen, the fact that they had accommodation as they traveled was shown to mean they were not homeless. But these other kind of principles were also set out in the same cases. Number 7, you need to submit certain documents before accepting that case. As I say, I should probably put these together where they're kind of asking for things like, I mean, in fact, if I think, if I just go down a couple, no, maybe not. So yeah, this is probably just reiterating the same sort of thing I've already said. Again, it's kind of, it's not about putting these additional hoops involved. There's another LGO decision, which I don't think I've put in these slides, which basically says the council should accept the duty first and then make inquiries. It's a London case. It's like Bromley or something. But yeah, if you've attended the 1 day's training, you'll see that in the slides. That kind of underlines this principle that you trigger the application and then they ask for documents, not the other way around. You must use your online portal. This kind of does come back to this Jigsaw question that came out earlier. So as I say, Jigsaw's one of the many systems that you might encounter with, that councils use. And the counter to it is, and as I say, you'll just get a housing officer ringing you up, just being really, quite frankly, shitty with you because you've not followed their form. But so you have to kind of, that's kind of where this rubber hits the road. That's when you have to start digging your heels in and saying, look, I can make an application any way I want to for this person, and it's in their interest to do it via email. It's not in their interest to do it via the Jigsaw thing. So you would quote 18.5 of the code the guidance, which basically says applications can be made in any particular form. But sensibly, you might just take the line, okay, well, we'll do the email. We'll then confirm that the council's accepted the application when you have that conversation with the annoying housing officer, and then say, okay, look, once you've accepted the duty, then we will fill in the Jigsaw form. We'll do the online form. Sure, that's not a problem, but it's just kind of making the point that the information you actually needed to give was in the email. One of another problem with the duty to refer form and the online portals that you get is that it doesn't ask you for enough information to actually sometimes show that there is a duty, and it's just because it doesn't ask for it, rather than it doesn't kind of get the information in a way which is actually going to satisfy these duties. Number 9, you have to be verified with the rough sleeper team. This is our favourite. Again, this is it's nuts that this happens, and this is like a widespread policy. But going back to 18.5 again, applications can be made and expressed in any particular form. So if you say, I'm rough sleeping, can you help me out with housing, to a housing officer from a house, or from any local authority officer from any local authority department, that triggers the application because there is reasonably that person might be homeless. You don't need to, again, it's like it's asking for proof that you've been evicted or something to be verified. That is not necessary. Most people who are sleeping rough will be in priority needs, so they will have additional vulnerabilities, which means they certainly may be in priority needs. And so interim accommodation should be provided rather than telling people to go and sleep rough. That's the way it should work. If any of you come across cases like that, I'd be very interested in sort of hearing about them if you get the person's consent, because it's, as I say, it's such a widespread issue, and it frustrates the purpose of the law. Number 10, you need to bring proof of homelessness or letter from the doctor or whatever. Again, we kind of covered this. So in fact, I think this might be the one that I wanted to see earlier. So in this case, the Bromley case, therefore, I consider the low threshold for accepting homeless application was met. At that stage, the evidence does not have to confirm the person is homeless or threatened with homelessness. The council only has to have reason to believe it might be the case. And then if you look at this Tower Hamlets excerpt here, it should have provided interim accommodation and then asked her for evidence. So she was somebody who said she was pregnant. They should have accepted that there was therefore reason to believe she might be in priority needs. And once they've accommodated her, they should then ask the midwife for whatever documents they want to confirm that she is in fact pregnant and therefore in priority needs. I think we're up to 11 here. You need to go to different council. So this is the whole you have no local connection trick. That's definitely not lawful. I couldn't actually find an LGSCO decision which specifically deal with that. I guess you challenge it by going back to basics. Section 184 and Section 188 do not mention local connection, and that's the point you make. And in fact, you can make an application if you're threatened with homelessness and get the prevention duty without having any local connection, because local connection doesn't kick in at all at that stage. But even if you're actually homeless already, the initial duties apply to everyone. So you can't just be told to go to another London council, another council. There are some examples actually in the LGSCO report on gatekeeping, which I actually think I should have probably included them in the slides. But yeah, take my word for it. That's definitely not lawful. And similarly, telling people they're intentionally homeless and therefore they can't make an application again, you're just basically going back to basics, and you're showing how that in section 184 and section 188 it does not mention intentional homelessness at all, so it's not relevant. So yeah, just some comments going in there about verified rough sleeping. Yeah, I mean, the only way you're going to stop it is by a complaint. So in Bedford, they still do it, but they kind of do it without, they're going to try and stop us finding out about it. But it still happens. And so when you have those cases where you have someone, often what happens is you have someone who's got told that they need to go and sleep rough and be verified, and then it later transpired that they're in priority need for sure. Your complaint is actually then very strong, because what you're saying is they approached the council when there was definitely reason to believe that they might be in priority need, because they actually found out to be that they were. And yet this person was left homeless for a night. Even if it was just a night, there would be compensation available there, probably a few £100 just for that one night. So that's something that just needs to be tackled. Then we get a couple of more complicated ones to finish off. So you can make consecutive applications to the same council, provided there has been a change, even if it's a fairly kind of insignificant change, but it has to be more than trivial. Now, there was a case earlier this year which Will and I spoke about on his live stream a little while ago, called Ivory v. Well and Hatfield. And that kind of seemed to lower the threshold even more. It really did seem in that case that if there was anything new, any new information, it might be, a new medical letter or some other kind of, in that case, it was actually about someone who was found intentionally homeless from a property like 10 years ago, but there had been a subsequent assessment where a psychiatrist had basically said, the psychiatrist thought that this lady was affected by significant mental health issues at the time. That was then new information to trigger a new application. So, yeah, I'm not quite sure how often you actually come up against this in reality, but as I say, the threshold for making a fresh application, basically, if there's even a question, that would suggest that a new application should be accepted. So if something relevant has changed even just a little bit, that should be enough to trigger a consecutive application. Yeah, also, I mean, StreetLink, don't get me started on StreetLink, yeah, I'm not even going to slag them off here because it's just not worth it. Again, that whole verification process has specifically frustrated the way the law was designed. So when the law was written, it was written by people who cared a great deal about social justice, and they went to great lengths to make sure that the law was, had these low thresholds. So when you have something like the verification process coming along, something like StreetLink coming along, that's just basically throwing a grenade into what these duties should really be doing. Yeah. So again, so I'm just saying same issue where they are. Yeah. You've got to complain about it. Basically, it's very straightforward from a legal point of view, what's actually gone wrong. Then finally, you haven't got mental capacity to make a homes application. This is not so widespread. It is quite a problem in certain councils. And again, if you want to know more about this, go and check out this Mendip LGSCO decision, because it's the best single place I've found to explain what happens. But if you've got someone, because often what happens is, and I can think of a few councils that do this, where you have someone with mental health issues, and then maybe their last tenancy broke down because of their mental health issues, the housing officer will jump to the conclusion that they therefore don't have capacity to make an application, but they don't actually have a clue what they're doing. So in the Mendip case, it turned out that the housing officers didn't have any training about mental capacity at all. And so there was really no way on earth they were going to comply with the law. So you'd basically just want to pick apart, firstly, you'd really want to see a copy of that assessment to see whether it seems like it holds water or not. And you also want to see what other steps were taken to support that person to kind of make the application. So that's the slides pretty much. I guess we'll leave a bit of time for questions, but just to kind of give this overarching point, the first few cases are the hardest, but once you kind of push through that resistance, it will be like your magic, and you will find that you will be able to get pretty much everyone who approaches you housed. That's my experience of it, because the law is actually pretty darn good. It's just that it's been frustrated by lots of different councils because they've got their own little targets. And it's because there is this kind of lack of knowledge of the law, and also this kind of, these funding arrangements, which mean it can be quite difficult to challenge councils. I'll finish. I'll finish my bit with a stat, which you might have heard if you've been on the training before. But so referring back to Just Us, so back I don't know when it was, like 2021 or something, we did a stat exercise on the clients that we had, and we divided them into two columns. Those people who approached the council on their own in the first instance, and then people who approached the council with our assistance from the start. And for those who approached the council on their own, 86% of the time they were told there was no duty to house them, when there actually was, because we went, we knew there was, because we went back and got them housed. Whereas when we went with them from the start, it was only 12%, and that was because, as John alluded to earlier, because you've got a track record, because you build up a track record with the council, because they know you know the law, they know that you will basically challenge them robustly on these kind of things. They will then see you involved in a case, and they will treat your client like a VIP all of a sudden. That's kind of the reality to what it's seen. So I've even seen records from Bedford Borough Council where just the fact that we were involved, just the fact our email addresses were copied into a trigger email from someone else, that was enough to get the council to follow the law properly. So yeah, it's I'm not going to make out like this is easy. It really isn't, but it's worth it. And you can get people housed very simply by just getting this basic stuff done. Will, did you want to add anything to any of this? So I appreciate I've hogged it and gone through the slides, but I wasn't quite sure how we're going to do for time. So we actually seem to be doing okay. We've got another 10 minutes.
Well, the only thing I would want to add is that the what we've been discussing is there's a frustrating sort of dimension to it, which is that often the client or the applicant requires urgent assistance, and the complaints procedure may not be quick enough to get that. So it's frustrating. So what I would add is that everything that Mike said in terms of getting things resolved through complaints, if you really do need urgent accommodation, then judicial review proceedings can achieve the same results within a matter of hours. Even you can get an order in the High Court. The quickest I ever got one was in about half an hour of submitting the papers. Admittedly, it took me a couple of hours to sort the papers out, and a couple of hours before that to threaten the council. But the problem is just finding a solicitor, and we're trying to. I'm not advertising because I'm so busy that I'd be scared to take that much on. But at Virgo Solicitors, we are trying to sort of take stuff on. So that, because if you try and find a solicitor, you're usually told there's no capacity. But if you do need to find a solicitor, please get in touch, and I can try and help you. Because if the person's on the street, it's a great shame if you have to wait 6 weeks for a stage 2 complaint to resolve it. And again, it's the same thing. If they know that you're once you've taken them to court once, twice, they then start taking you more seriously. Although, having said that, a lot of the London, I deal mainly with London authorities, and it's just mind-boggling how unhelpful they are and how little they care about the law, on the basis that for every 100 people they mess around, maybe only 5 will get a solicitor who challenges them. But don't give up. Just make complaints and try and get solicitors if you can, if you need urgent relief.